Good afternoon. I am Judge Taylor, and this is the felony first appearance hearings. You can be seated. Thank you. Good afternoon to everyone. The first thing I would like for everyone to know is that to make sure that the public is able to access our courtrooms, we are live streaming this on YouTube. So not only are we recording it for magistrate court purposes, but it is being broadcast live on YouTube. So your attorney might not want you making any statements about your case that could be used against you later. With regard to the live stream on YouTube, there are to be no recordings made from that live stream. Any recordings have to be approved through magistrate court. So if you are recording and you have not received permission from magistrate court, you need to stop recording now. With regard to today's hearing, I would call this an informational hearing. I'm going to speak with you each individually to make sure you understand what your attorney has explained to you about your charges. I'm going to explain the process for your case in DeKalb County. And I'm also going to hear from your attorney and from the district attorney about your circumstances related to bond, as well as your criminal history, which I've already reviewed and which the assistant district attorney will review as well. Based on those facts and circumstances, your criminal history and your ties to the community, I'll make a decision on your bond. In some of your cases, I cannot set a bond, or in some cases, I may deny a bond. In either of those cases, your attorney has the right to go ahead and file a motion in Superior Court for bond. So it doesn't mean that you can't get a bond, it just means you're not getting one from me. Your attorney will explain all of that to you, or probably has already explained that to you. The next hearing that might happen in your case would be a probable cause hearing. A probable cause hearing is a hearing in front of a judge to determine if there was enough evidence to have arrested you on the charges. Not whether you're guilty, just if there was enough to arrest. If the judge decides there was enough to have arrested you, they would send your case over to the district attorney's office for their further investigation. They investigate the case and determine if there's enough evidence to present it to a group of people known as a grand jury. A grand jury is just a group of people from the community who listen to the evidence in your case and determine if there's enough evidence for you to have to stand trial, and if so, what charge or charges you should face at trial. If they decide you should stand trial, they're going to write up what's called a bill of indictment. That is a fancy name for the piece of paper that actually tells you what charge or charges you will face at trial. Your case is then set in front of a Superior Court judge, who is the first judge to talk to you about guilt or innocence in your case. In front of that judge, you can enter a plea of guilty and be sentenced, or enter a plea of not guilty and have a trial date set in your case. If you plead guilty or you're found guilty of any of the charges in Superior Court, you face a minimum of 1 year up to a maximum of life in prison, depending on the severity of your convictions. Some or all of that may be served on probation, again, depending on the severity of the conviction. If you wish to plead not guilty and have a trial in your case, you're presumed innocent of these charges. The state has the burden of proving the case against you beyond a reasonable doubt. You'd have the right to confront the witnesses against you, bring witnesses into court, testify yourself, and offer other evidence, as well as have the assistance of a lawyer at a trial. If you cannot afford a lawyer, we will appoint a lawyer from the public defender's office to represent you. Again, you do not have to testify today or at any court appearance, but if you choose to, it is recorded and it can be used against you later if you have a trial. I'm now going to speak with you each individually about your cases. I was going to go ahead and start with Mr. Jones. and then move on to the Superior Court only cases, and then the consents, and then we'll have the hearings. Is there any problem with that with the deputies in the courtroom?
Is that Christopher or Sheldon Jones?
I'm sorry, it's Christopher Jones.
Yes, ma'am.
All right, thank you. All right, and who's representing Mr. Jones?
Good afternoon, Judge. Megan Merrill from the Public Defender's Office. I'll be representing Mr. Jones today. We have reviewed the warrant with him and we do waive reading.
All right, thank you. And good afternoon, Mr. Jones. You are charged in case number BH21-003921 with 1 count of aggravated assault with intent to murder, 1 count of aggravated battery, disfiguring, and 1 count of cruelty to children in the 1st degree. Your attorneys had a chance to go over those charges with you, and so I'm now going to hear from her with regard to your bond situation.
Thank you, Your Honor. Mr. Jones is 30 years old and he has lived here in Georgia for the last 12 years. He currently works at a grocery store as a stalker. He's been doing that for the last 2 years. He is currently homeless and has no ability to make a bond. We understand that the nature of the charges here, and we understand his criminal history, which I'm sure the state will inform you. I would like to point out to the court that he has no previous violent felonies. And so we are asking the court to consider setting a reasonable bond in this case.
All right, thank you. Ms. McMichael?
Yes, Judge, the state is asking for no bond on this case. The facts are clearly egregious. The victim in this case does not know the defendant and was attacked and has had to have multiple surgeries. The defendant is clearly a danger to society. Then you'll add on to that his past criminal histories indicates that he is not a very good candidate for bond. The defendant does have multiple arrests in multiple states, and he has a juvenile arrest out of Tennessee. In Alabama in 2016, he had possession of a forged instrument. In Georgia, he has a total of 12 arrests, 2 cases of which are pending here in DeKalb County. 2011 was a misdemeanor theft by shoplifting, and that 2011 also resulted in a failure to appear. In 2016, he has a disorderly conduct. In 2018, a simple battery. 2019, a robbery. That case is pending. 2019, a simple assault. 2019, failure to appear. 2020, theft by conversion. 2020, theft by receiving stolen property, and also in 2020, a theft by taking. That case is also pending here in DeKalb County. Based on the nature of the case and the defendant's criminal history, the state is requesting no bond.
All right, well, based on the facts and circumstances, as well as his criminal history and being out on bond on 2 charges, one of which is arguably a violent charge, I do find that he is a risk to the community, and I will deny bond at this time. And again, Mr. Jones, that just means your attorney can apply to a Superior Court judge for a bond. All right, anything further on Mr. Jones's case?
Nothing from the defense, Your Honor.
All right, thank you. Now, I had a notation that defendant case number 5, Mr. Heath, I had him noted as Superior Court only because he has a first offender conviction in, or he's on first offender probation for an aggravated assault in Fulton County.
That is correct, Your Honor. That was not originally notated, and I apologize for that.
Okay, no, that's fine. I was going to go ahead and start with Mr. Heath. Mr. Heath, you can come on up. Good afternoon, Mr. Heath.